All right, cool. I'm gonna drop. Hey guys, Abe Ovadia here. I'm in my studio where we do shoot our podcast. I'm gonna drop a couple links. One, if you guys want to get updates from me, you could subscribe from my newsletter where I send out stuff about the changes to the law. If you're not already on it, some of you I volunteered as tribute and put you guys on already. But if anybody wants to subscribe for that, they can. I got another link I want to share with you guys. A lot of people are asking for the video. I have links right here. House Bill 837. You could watch it. It's on our website. We have multiple videos about what I'm going to talk to you about. Obviously, that one's not interactive. We shot that footage on Monday, got it up on the website because we knew it was important. Also, I just got back from a week-long cruise, so I was beautifully tanned. So it was just like that John F. Kennedy versus Nixon. Nixon didn't have that tan. JFK had that tan. He won. For those of you guys who are in history, that's what they tell us anyways. Rod, you'll let me know. But anyways, hey guys, so wanted to talk to you guys about House Bill 837. We've done a couple of these already. We had like 250 people on the last one, and the one before that, 200 people. A lot of people have questions, so we wanted to get the word out there about what's going on with the changes to the law. To be honest with you, except for the removal of attorney's fees for 99% of PIP suits, except for the removal of attorney's fees for PIP suits, on 99% of the cases, very little has changed in the world of personal injury. The original version of the bill was horrific. It was terrible. The original version, I'm gonna go line item by line item for the big ones. The original version was devastating to anyone who's injured as a result of someone else's negligence. The key takeaway, I mean, most of you on here are chiropractors. The key takeaway for you is just the attorney's fees for PIP, and a lot of people say, oh well, attorney's fees for PIP, right? Like that's just Abe. That doesn't affect me. But what it does do is it stops it's accountability, right? Attorney's fees for PIP is accountability for the insurance companies to keep them honest. If they want to shortchange you $1,000, then under the old law, there's attorney's fees. I'd sue them for the $1,000 and they'd pay. And $1,000 to you adds up with every claim you get each month, adds up to $100,000 or more down the road. So that's why it's important to have attorney's fees. But unfortunately, the legislature got rid of that just recently. Now, to talk about the minor stuff really quickly. One, personal injury always had a statute of limitations in Florida for 4 years. Personal injury, 4-year statute of limitations. It got reduced to 2. PIP suits, there's still PIP suits. For those of you who are like, what? There's still PIP suits, and it's still a 5-year breach of contract statute in Florida. 5 years, breach of contract, PIP suits, 5 years. So the only thing that changed there is personal injury cases have to be settled or filed within 2 years. Not a big deal. Personal injury lawyer is going to cry about it. It's not the end of the world. It really doesn't affect us that much. Comparative negligence, that's another area that was changed. This might affect some doctors. Comparative negligence in Florida, let's say someone's claim is worth $1 million. Let's say it's worth $1 million. They've got really bad injuries, severe injuries. If they were, in the old days, if they were 99% at fault and their medical bills and their pain and suffering, all that stuff, let's say it's worth $1 million. If they were 99% at fault, they could collect 1% of that $1 million. Okay. Under the old law. Under the new law, if a jury decides that someone is 51% at fault for their own harm, for causing their own harm, then they recover 0. So 51%, this is a lot of he said, she said cases, right? It always reminds me of those cases where 2 cars are on the highway. One is merging into the highway. The other one is already on the highway, and they both bump each other's sides, right? And they're like, no, that person merged into my lane. It's always the other person's fault. That case, most likely, under the new law, is not a case, because what'll happen is the insurance company will say, oh, the magic number, 51% at fault, even though it could be 50-50, right? If they say the magic number, 51%, the question then becomes, is this case worth going to court? And unfortunately, if there's not massive amounts of injuries, right, then it's not worth going to court, because a court case could take 2 to 3 years. So under the new law, if you have any cases where two cars are, you're treating a patient and the other driver and your client, their two cars rubbed on the side of each other while they're driving on the highway. Not a case really. If still have it reviewed by an attorney, right? You're not a lawyer, you shouldn't make a legal decision, but have it, reviewed by an attorney, but possibly not a case. Let's say a pedestrian wearing all black crossing the street in the middle of the night where it's poor lighting, they're not wearing reflective gear, right? That person, under the old law, an insurance company would say, hey, maybe our driver didn't maintain a proper lookout. Maybe if they were a little bit more alert, they would have seen this person. So we'll give you some money, okay, because you're hurt really bad. But under the new law, they're going to recover zero, most likely. A lot of bikers went up to Tallahassee to say, hey, there's no law in Florida that requires us to wear a helmet. But if this law passes and I'm not wearing a helmet, and let's say I'm stopped on my motorcycle at a red light and someone rear ends me, and I end up having a massive brain injury, under the new law, it could be interpreted that they caused their own harm by not wearing a seatbelt. By not wearing a helmet. So that's another thing. If somebody's not wearing a seatbelt, that could be another thing where they recover zero. Okay. So again, 90% of cases aren't going to be affected by that, but it's for that one person who is affected by it, it sucks for them, right? The change. We talked about the statute of limitations. We talked about comparative negligence. Now we'll talk really quickly about LOPs, which is a hot button for you guys. LOPs, a lot of people are asking about that. So the original version of House Bill 837 for LOPs said this. It said a jury can only hear what the Medicare rate is, the 100% of Medicare rate is for those bills. It didn't even allow for the doctor's bills to be seen by the jury. That was the original version. That would have been horrific, right? Imagine being a chiropractor and you have $15,000 in bills, and we know that Medicare doesn't pay chiros for exams. We know they don't pay them for anything but an adjustment. No x-rays, no therapies, just an adjustment. A jury wouldn't see that you had a $10,000 bill. They would see that that Medicare pays $500 for quote unquote the services received by the patient. So that was the original version. The final version is different. The final version, they changed the language to, and I got it here. They kept changing it so many times. It was the weirdest thing. They changed it to, a jury will hear 120% of the Medicare rate, so 1.2 times whatever Medicare would pay. If it's not reimbursable under Medicare, they'll hear 170% of what Medicaid would pay. And then they would also get to hear other evidence, which is the doctor's bills, okay? If the patient has health insurance, most of my clients don't have health insurance in a car accident setting, they don't have health insurance. But if they did have health insurance, a jury would also hear what health insurance would pay for those services. So if somebody has health insurance, a jury would hear the Medicare rate, they would hear the doctor's bills, and they would hear what health insurance would have paid. Now, listen, if somebody's, let's say they're 40 years old, a jury's going to hear what Medicaid would pay, right? Medicare would pay. Who cares? I'm a personal injury lawyer. I would explain to the jury, hey, this person's 40 years old. They don't qualify for Medicare. Why? Who cares what that lawyer is telling you Medicare rate is? Because guess what? They're not Medicare eligible. So what does it matter, right? Also, the doctor, let's say it's a surgeon, right? Let's face it, the chiropractor most likely got paid from PIP, the majority of their bills, if it goes to trial at that point. So let's say we're talking about a surgeon. If there's any surgeons on here, or pain management doctors, right? And they say, oh, this is what doc, you get paid this amount of money for Medicare, right? Well, yeah, Mondays and Tuesdays, I treat Medicare patients. The doctor may look a little foolish on the stand, but also let's say that doctor doesn't take Medicare, right? Well, yeah, I understand what Medicare pays, but I personally don't take Medicare because the reimbursements are so low. And also when I bill Medicare, they pay me within 30 days. And also, when I accept Medicare patients, guess what? I get flooded. My entire lobby is full of patients with Medicare. And so it's different, right? Why should this person who caused this accident get to pay Medicare rates? So also, one of the doctors had asked me before, does that mean that the doctor has to accept this bizarre 120% of Medicare rate? No, that just means that a jury will hear evidence of that amount. So they'll have their own choice in deciding what's fair and reasonable. And to be honest with you, I'll tell you why this is really just a nothing burger of a change is this LOP law. For anybody who's tried a personal injury case before, you know that juries would already hear this information because a billing expert would get on the stand and testify, oh, I'm a billing expert. I've got 20 years experience. I've never done surgery. I don't know how to do surgery, but I think, in my experience, that Medicare pays a reasonable amount. And I think that this doctor's bills are so high and that they should accept Medicare. And juries hate that because that billing person is not a surgeon and doesn't treat patients. So I think that's really a nothing burger of a change, the LOPs. A lot of people were worried about it because the original version was the jury can only hear what the Medicare rate is, which would really suck. But luckily, the FJA and other organizations like the FCPA fought against that and were able to get the changes made so that the jury hears all the information, which they already got to hear anyways. This just puts it into law. Also, I want to talk to you briefly about bad faith. Bad faith was changed, but it's really, again, not a big deal. And then after that, we'll talk about the PIP. Okay, I want to talk about that because that takes the most time. But the bad faith law, I'll give you an example of bad faith under the old laws because this is a pretty well-known case, United Auto case. They very rarely sell bodily injury policies, but when they do, they somehow manage to goof it up sometimes. There was a case in Miami. A guy crosses an intersection, hits and kills a judge. They have a $10K BI policy, $10,000 BI policy. Any insurance company would say, oh my gosh, a judge was killed. Give the $10,000 to the judge and let's get absolved of any problems here, bad faith. So United Auto, for whatever reason, lawyer sent the letter. They didn't tender the $10,000. Lawyer sent maybe another letter. Hey, maybe you didn't get my first letter, but here's my second letter, certified mail. You need to pay the $10,000. And they didn't respond. So guess what? They didn't pay the 10,000 policy limit. So guess what? The lawyers in that case, you would assume the judge, his family hired some pretty brilliant lawyers. They sued and they were able to convince a jury that United Auto committed bad faith by not tendering the $10,000 limits. And guess how many millions of dollars they recovered for their deceased client, a former judge. Not one, not two, not three, but $10 million, not $10,000. That's what the insurance was. A jury felt that United Auto's behavior in that case was so bad that they wanted to award $10 million to the family. And guess who had to pay that? United Auto, not the driver of that car, who, you know, we know United Auto has the ability to insure, I think 90% of all the 1990s and early 2000 Toyota Corollas. So I'm assuming the guy who's driving that 1995 Toyota Corolla did not come up with the rest of the $10 million. It was United Auto. And because of their bad faith, right, they had to pay. Now that's the old law. Under the new law, the insurance company is going to have 90 days from receiving, quote, substantial evidence of the claim, 90 days to pay out the policy limits. The original version of the bill, for people who followed the changes, the original version of the bill was horrendous. It said that an insurance company has absolutely zero liability for any bad faith acts until 90 days after a lawsuit is filed. So let's say you file a lawsuit, the insurance company could still offer nothing on a case, and on the 90th day of a lawsuit, they could file the policy limits, send that over to the personal injury lawyer, okay? And then there's no bad faith, and the insurance company could walk away, which meant that no case would earn anywhere close to its settlement value. until a lawsuit would be filed and the 90-day would expire. So under the final version, I just want to make clear, 90 days from the day they get substantial evidence of the claim, which is like a personal injury demand letter. Personal injury demand letter is you get all the bills, all the records, the police report, any facts about your client you want to share, and you send them a stack of 100 to 200 pages of medical records and bills and say, hey, pay me the policy limits. And if they pay, great. If they don't pay, you may or may not have a bad faith claim, but these days it's very rare, to be honest with you. This will make it more rare to have bad faith, but there's still bad faith laws in place. So again, that's kind of a nothing burger. The lobbyists did a fantastic job of positioning for that. Now, PIP, let's talk about PIP. A lot of people are freaked out. One of my own guys, I'll be honest, I was on a cruise last week. When the governor signed the bill on Friday, I was on a cruise. I didn't have cell service on purpose. I get all these doctors who don't talk to me. They avoid my calls. But when something happens like this, they freak out and call me. And that's okay. But I'm not taking their call on my nice 1 week cruise that we took down to the Bahamas, Jamaica, and Haiti. Haiti was beautiful, by the way, for anybody who thinks Haiti's a scary place. Obviously, I'm sure there's a war zone right now in the capital and other places, but in this resort town, it was totally safe. Some people were terrified to get off the cruise. A long story short, it was beautiful, but I was gone, and one of my guys told certain doctors they got rid of PIP. And when I got back, I was like, no, he forgot the part where they kept PIP. They got rid of PIP attorney fees. And let's talk about that, because a lot of people think, oh, if they get rid of attorney's fees, that's just the attorneys. Who cares? Well, listen, the attorneys who do PIP suits, what we do is we're the muscle, we're the hammer that drops when the insurance company doesn't want to pay your bills. I had a doctor call me a couple weeks ago, Abe, Geico is claiming fraud on this case. I didn't do anything fraudulent. The guy works 2 jobs to survive. I don't know what he did fraudulent, but like, I didn't do anything. Geico is saying there's fraud on this case and they don't want to pay my bill. I was like, send it to me, because Geico couldn't prove fraud if there was like cash exchanging hands right in front of their face. They say fraud a lot of times and they don't know how to prove it. And they don't even have proof that it exists. They just make it up sometimes. And so in that case, I said, send it over to me. I'll make sure you get paid, because, you know, obviously I'm assuming that there is no fraud and that there's no proof of fraud, which is, in my experience in 12 years, I've very rarely seen an insurance company show me anything fraudulent. And if they do, guess what? Hey, I don't want to be involved with this. I'll drop the case. I'll advise the doctor that it's not a good case, and we'll walk away from the bills. Okay. But long story short, there's no attorney's fees, which means there's no way to keep the insurance company honest. Now, in a small subsection of cases, there's fees, but it has to be, and I'm going to quote the law here because it's a weird new phrase that they made up. And weird new phrases I like, because weird new phrases means litigation. It means the insurance companies don't know what it means. So here's what the law says. Where are we at here? Total coverage denial of the claim. Total coverage denial of the claim. So I want to explain that, because at first blush, total coverage denial of the claim means that an insurance company denied the case, right? They didn't pay anything. So let's say for instance, an insurance company denies a claim for fraud. That could be total coverage denial of the claim. They're denying the coverage, saying there's fraud. Let's say somebody doesn't show up to an IME, or they don't show up to an examination under oath. That would be a coverage issue as well. Let's say the insurance company, so that's one side. On the other side, where I can guarantee you there's no fees, is if an insurance company pays all of your CPT codes for each visit, and they don't pay, they pay all of your CPT codes, but let's say they shortchange you $1 here, $5 there per code, but they pay you on all the codes. That is not a total denial coverage of the claim. So on one hand, there's fees if there's a total denial of the coverage of the claim. And on the other hand, the insurance company paid all of the CPT codes, but they paid them wrong. Okay, so fees for one, no fees for the other. What about the scenario, and this will be litigated for sure, okay? I don't know how successful it will be. There will be someone much smarter than me going to court presenting this claim. But what if an insurance company pays 4 out of 5 CPT codes? What if an insurance company says, you know what, we're going to pay for these 4 codes, we're going to pay you 0 for this other code, and we're going to cite some obscure Medicare guideline here from 20 years ago, buried in the text, and we're going to pay 0, which insurance companies have been known to do. And so in that instance, there could be a claim for attorney's fees, okay? There could be a claim for attorney's fees. In that instance, I don't want to promise you that. I'm an optimist. I'm gonna say right now we're gonna defer and punt that to a year or two in the courts and see what happens. But realistically, the way they wrote this law, okay, if a doctor is paid 0, there could be attorney's fees. But here's the part. Here's the part. If a doctor is paid 0 for the entire claim, they denied it for fraud, they denied it for IME no-show, right? In that setting, the lawsuit, in order to get attorney's fees, must be brought in the name of the patient. So it can't be brought in the name of the doctor's office as the assignee of the patient. It's got to be brought in the name of the patient. Who represents the patient? The personal injury lawyer. So the personal injury lawyer is either going to have to learn how to do PIP suits, or they're going to have to refer those cases out for PIP litigation to a PIP attorney. The PIP attorney will most likely pay a referral fee, 25% to that injury attorney to handle the claim. And let's say the lawyer is successful. The PIP lawyer, personal injury lawyer representing the patient is successful. Under the old law, and I got good news coming up in a second about that. Under the old law, the PIP attorney would get the doctor a check for $10,000, right? If I represent a chiropractor and PIP denies it for some BS reason, and I sue and I win, I get a check for $10,000 for my chiropractor. Happens all the time. We get $10,000 checks. I just brought a doctor 80 grand in checks yesterday. It was 8 claims, like a couple families of car accidents that an insurance company denied. We got him 80 grand, $10,000, eight cases, okay? It happens. And so under the new law, check goes in the name of the patient to their lawyer. And guess what the lawyer is going to say? He's going to say, or she is going to say, hey, doc, I love you. You're awesome. But you're going to get $6,000 because I got to pay the MRI center. I got to pay the orthopedic doctor. I got to pay the other doctor, whatever. You're going to get X amount. You're not getting the 10. Doesn't work that way. Check is in my law firm trust account, and I represent the patient, not you. So you're going to have to learn to live with that, guys, in that scenario. I'm just telling you straight, okay? Because that's, I don't even get paid to tell you straight. I'm just telling you straight. Now, the good news. The old law. So the governor signed the bill on March 24th, and the way the bill reads for PIP suits, it says, we go by the date the policy's issued. So for instance, if a policy is issued on March 24th, the day the governor signed the bill, or older, so March 23rd, March 22nd, if the policy was purchased by the driver or insured on March 24th or older, there are attorney's fees, which is great news, right? If I had that button right now where everybody could clap and it's like a pre-recorded thing, it would be that. You can still get attorney's fees for any claim where the policy of insurance was bought on March 24th or older. If it's bought on March 25th, there's no attorney's fees. It does not go by the date of loss. So I want to emphasize that. If somebody buys a policy on March 24th and they get in an accident, March 24th is the old law, and they get in an accident 4 months from now, it doesn't go by when they got in the accident. It goes by when they got the policy. So if anyone's watching this and they want advice, I would say make sure you get a copy of that insurance card. Make sure you find out from your patient when they purchased that policy and the exact date, because people right now are getting in car accidents today. They bought the policy in January, in February, in December even. And so those are still going to qualify for attorney's fees. So what I recommend everybody do, and I know this sounds a little disingenuous because I'm a PIP attorney, but make sure that you are getting your PIP files to your PIP attorney. They could be tall and good looking like myself. They could have a really great sarcastic sense of humor like myself, or they could be somebody else. But make sure you get your files to a PIP attorney to get them reviewed. Why? Abe, come on. What are you talking about? Listen, everybody is getting their PIP files out to PIP attorneys right now. It's happening. So if you are the person living under a rock, or you're still saying, no, I don't believe in PIP suits. You know how some people say I don't believe in chiropractors as if they're the tooth fairy? They're real people. And yes, I treat with chiropractors all the time. But you know how people say, oh, I don't believe in that, right? If you're still one of those people who says I don't believe in PIP suits, guess what? That's okay. We're going to get the PIP suit money for the MRI center that you've referred your cases to, for the orthopedic doctor that you've referred your cases to. And you're going to get a bunch of benefits exhausted letters when you're ready to make that jump to do PIP suits. So I strongly encourage everybody, don't miss the boat here. Why? You're not going to make more money under this new law. The new law is designed to not take away money from you, but to make sure that you don't make any more money. Okay. And I want to emphasize this too. Save your money, lower your overhead, but don't freak out. Send your files to me for PIP suits, but don't freak out. Okay. The sky is not falling. There is still PIP. There is still $10,000 available for care. It pays better than health insurance reimbursements. It pays better than most of your cash patients per visit. Okay. It is still here. It's still a no fault state. I can pretty much guarantee you that in 2 years, there will be no more PIP at all. Unfortunately, other organizations, primarily personal injury lawyers, want to get rid of PIP. I do both. I'm a personal injury lawyer, PIP suit lawyer. We do several other things. I represent doctors when they get sued by insurance companies. Okay. But my point being, there won't be PIP here much longer. Okay. Get your PIP money now. Okay. Get your PIP suit money now. Save your money and reduce your overhead. But do not freak out. Please don't freak out. A lot of people are scared. They're freaking out. They're shutting down their practices. I can promise you this, guys. You won't make more money. You won't make that much less money. Okay. Insurance companies, they still have a duty of good faith to pay bills. You can still sue the insurance companies, guys. Guess what? I didn't mention that. You can still do your own PIP suits. Even if there's no attorney's fees, attorneys are out there. They will do PIP suits. If an insurance company gets that crazy and that out of line, my office is still sending demand letters from now until the time they get rid of PIP. We're going to send demand letters. Okay. Are we going to file suit on every case? In the past, if an insurance company owed a doctor $50, I would sue because that's my job. I would sue the insurance company for the $50. I'm still suing them for the $50 because, first of all, it's not $50. It's $50 times 100 claims where they did that to. Okay, 100 patients where they did that to. That money adds up for my doctor. And then think about all the other doctors that they've done that to. Okay, I'm the hammer. I'm keeping the insurance companies honest. Okay, under the new law, for policies purchased after March 24th, meaning a policy was purchased on March 25th or more recently, March 26th, March 27th, then that means there's no attorney's fees. So can I sue an insurance company for $50 and keep a percentage of that? No, I can't do that. Could I sue an insurance company if they owe you $10,000 or $8,000 or $5,000 and keep a percentage? Yes, I can. We would have to keep a percentage of it. You would have to work out some kind of a deal with us where we would get paid for it somehow. I have no comment to tell you yet what to charge. I can tell you this, my price for a demand letter is staying the same. I've already heard, and this drives me insane. I don't charge anything to send a demand letter. I keep the interest and I keep the penalty. You keep 100% of what you're owed. If an insurance company owes you $5, you'll get $5. I'll get 10% of $5 in a separate check. So the insurance company will cut a separate check for 50 cents, and then they'll pay me 4% interest on the $5. Okay. It drives me crazy. There's people out there already. One guy in Miami told one of my doctors, I'm charging 25% to send demand letters effective immediately. 25%. It drives me crazy. I don't charge anything, guys. Send me your cases so I can send demands at the very least. We don't charge any money for that, guys. And don't be I mean, there's no other word for it. Don't be a schmuck. Don't pay 25% to some guy who never did PIP suits, or maybe did PIP suits but is now charging 25% to send a demand letter. Please don't do that, guys. Send your files out. We have people that can go to your office and pull the files for you. We'll send the demands for you. If we have to file a suit, we will. But please don't pay 25% for someone to send your demand letter. It's crazy. So the good news about the law, there's still PIP. You still need an EMC. There was some misinformation about that. That's been corrected, but you still need to get an EMC done. And there's still $10,000 in care. That includes for chiropractors, still $10,000 in care. If you guys have any messages you want to send them in, feel free. You can tell me, hey, Abe, you're the best speaker. You got the coolest background ever. Or you could just ask me a legal question. Either way is fine. It's all good. But you know, happy to answer any questions you guys have. So the good news is there's still PIP and there's still money, attorney's fees for your old cases, which means they're going to pay. Now, under the new law, let's say I send a demand letter. They may call me and say, hey, Abe, listen, you're saying that we owe you $2,000, but you know, we're an insurance company and we have some weird reasons, but we think we only owe you $1,000. How about we settle this out right now somewhere in the middle? Give us a call. That's possible. I'm not going to like that, but that's possible, right? You know, we would obviously still, the law actually requires us to send a demand letter anyways. So under the new law, let's say there's no attorney's fees, right? And remember, policies are 6-month policies. So if somebody bought a policy on March 1st or March 24th, they got 6 months, guys, of that policy, meaning there's attorney's fees, meaning the insurance company is going to have to pay you. Either they're going to pay your bill in full when you send it, when I send a demand letter, or when I file a lawsuit, but they're going to pay it. So we're talking really realistically here, August, September, most of those accidents are going to be under the new law. So you're not going to see an immediate thing here like some lawyers are Chicken Little. Oh, the sky's falling, it's over, start selling your practice. No, there is still going to be a very, I think the insurance companies are going to keep the same rhythm for a while, okay? And before we see any changes, we'll be at least in August, September. So please don't freak out. Somebody said here, when you say the policy was active, what does that mean? That means when the policy was purchased or when it was renewed, however you want to call it. But it's when somebody says, oh man, my policy of insurance is going to expire tomorrow, I need to go buy insurance. When they pay for that 6-month policy, that's the effective date of the policy. It literally on the declarations page will say effective date. Okay, so hopefully that answers your question. If it doesn't, please let me know. Please message me back. What about IME cutoffs? Does the patient or the patient's attorney become the assignment holder? Okay, so an IME cutoff. I do think that insurance companies will start, certain insurance companies, I gotta reemphasize that. I think certain insurance companies, not all, certain ones will start to do IME cutoffs. I think that they can. I think that it makes sense for them, except for the fact, like I said, if an insurance company denies certain claims, right? Like this is a good point, okay? When you submit your bill to the insurance company, you put it on a form. What is on that claim form? Somebody help me. I know you're all muted. It says health insurance claim form, health insurance claim form, okay? Now, the way the law reads is it says if it's a total coverage denial of the claim. So you put it on a claim form. So if an insurance company denies your claim form, they deny your claim form, is that a total coverage denial of that claim? Maybe there's attorney's fees. So I think the insurance companies are going to do IME cutoffs on a lot of cases. I think that could present an issue where, hey, judge, what do you think about this? Maybe a judge agrees, maybe a judge doesn't agree. Who knows? Okay, somebody's asking here about 80,000 lawsuits filed. I don't know anything about 80,000 lawsuits filed. I know Morgan and Morgan had a little publicity stunt, and they said that they filed 23,000 lawsuits in 30 days. Um, I don't know. There's really no way to prove that they filed those 23,000 claims because they're all under different lawyers' names and they're all in different counties. And the lawsuit is titled, you know, the name of their patient, their client, versus somebody who hit them. Really hard to prove that. But let's say they did file 23,000 lawsuits. Okay. It's not unbelievable that they would have that many cases, but let's say they did. Not all of those are car accidents. Okay. A lot of those are probably negligent security cases, which they had their own laws affected as well. Some of those, there might be a variety of reasons, but what's going on right now in the courts is the clerk of courts are freaked out because not just them, my office, every personal injury lawyer should have filed lawsuits before the law went into effect because the changes that I told you about LOPs and bad faith and all that, if you filed the lawsuit before that date, the governor signed the bill, then you get the old law, which is slightly more favorable. It's not a slam dunk more favorable, it's just slightly more favorable. And the clerk of courts are freaking out that, hey, we're under budget already, blah, blah, blah. But I will tell you this, Progressive is settling every lawsuit with my office already. Progressive is settling every lawsuit with my office. If you have Progressive cases and you want to get paid, even the benefits exhausted cases, they're saying, hey, Abe, we'll give you some money. Okay, even on cases where they don't have to pay. Why? Because they know that every other person who does PIP suits is going to sue them on that claim. Okay, after I get it, you're going to give your files to somebody else. They're going to get the files from somebody else. So they know that if they settle it with me, they're not going to get 3 more lawsuits. So Progressive is already settling every case that's including benefits exhausted cases. Okay. Ocean Harbor is settling every case with us. If you have any Ocean Harbor cases, we're settling all of those cases. Don't be the last person in line and told, oh, well, benefits are exhausted, you don't get anything. Who else is settling big right now? Geico. Geico has just made an offer to settle all of our cases, and that's moving along. So look, a lot of insurance defense lawyers are going to be looking for jobs. That's a fact because the insurance companies, they don't have to litigate cases. They can just settle them. And so make sure you get your stuff out. Can the insurance company request an IME at any time? Okay. Man, this guy's asking some good questions. I like your questions. An insurance company can request an IME right after an accident. They don't have to wait till bills are received. Some people are suggesting, and man, this is like torture. There is a piping hot Dunkin' Donuts cup of coffee on the other side of this computer, and I'm desperately wanting to drink it, but I know it's getting colder by the minute, but I'm gonna wait. I'm gonna finish this out. It's torture right now. I haven't had any coffee all day, but an insurance company can do an IME at any time. There are some people who are saying, hey, let's change the way we do things. Let's change everything and let's send a notice of initiation of treatment form. A notice of initiation of treatment form, and I'm going to get you guys the link right now. I'm going to type on Google, Ovadia Law is the best law firm in the world. No, Ovadia Law, notice of initiation of treatment form. Man, I'm typing so fast right now. This is like unreal. Here's the form. I'm going to plug it into the chat for you guys. I don't recommend you send this. I 100% am telling you that everything is going to be okay. Everything is fine. I do not suggest changing anything, okay? But I sent you the link for a notice of initiation. Under the old days, for anybody who's been around this game a while, 2003, January 1st, before that day, you could send your bills in whenever you wanted to. You could just pop them in the mail when you were done treating the patient and say, here you go, insurance company, here's 3 months worth of treatment. And in 2003, they changed that to make it a 35-day requirement. You got 35 days from the date of service. You're going to tempt me with that coffee? Man, you're torturing me right now. Thank you. They messaged me an emoji of coffee. Under the old days, you could just pop the bills in the mail and the insurance company would get hit with them and they'd have to pay those bills within 30 days. Nobody sends that form out anymore. Some guys would tell me, Abe, this is the old timers. Abe, What I do is I send, first you got to send in this form, and then you got 70 days to send out your bills. But what they do is they wait till the last day, day 70, and they pop these in the mail. Okay. And the insurance company is like, oh man, we got 2 months worth of treatment and we can't send them for an IME now, because if we do, it's going to exhaust anyways. I don't recommend doing that. One, a hospital could throw in a bill, a pain management doctor could throw in a bill, an MRI could throw in a bill. It's going to take away from the benefits. Just send in your bills like normal. Okay, what happens if you send in 2 months worth of bills in one, because you're doing things under this spicy notice of initiation of treatment? It is in the law. It's always been in the law. Nobody does it because it's unnecessary. But who wants to wait 2 months to get paid when you can send out your bills every week and get paid, right? So bottom line is, I don't recommend doing this. I am not Chicken Little on this issue. The sky is not falling. Keep billing, keep doing everything the norm. You might see a decrease in money coming in. Okay, you will see a decrease in money coming in, but it's nothing that's going to be earth shattering where you're going to lose your practice. If you tighten your belt and you save 2 to 3 months of income, I suggest saving at least 6 months of income. But if you tighten, 2 to 3 months of income, you will weather the storm. Okay, there will not be an immediate shift. Not every case is going to be an IME cutoff. Not every insurance company is going to tell you that they're not paying you a penny. Okay, that's nonsense. The insurance companies have a duty of good faith. They will pay. If they don't pay, you can still do a PIP suit, guys. There's still PIP suits, but you're going to have to either pay a percentage or pay a flat fee to an attorney. My office will always send a demand. Again, for the minimum, we keep the interest, we keep the penalty. If you have a problem with me keeping the 4% interest and the 10% penalty that's capped at $250, you're crazy. Some people are paying 25%. Sounds pretty reasonable, right? So just make sure you keep sending out your bills normally. Would it be possible to answer the question regarding PIP benefits? Oh, you know what? I skipped over you were the first question. Sorry. Under the new laws regarding 51%, does the injured person still receive any of their PIP benefits? So great. That's actually a great question. I like that one. So again, it's still no fault, and no fault law is not affected by the 51%. The 51% rule only affects personal injury lawyers who are bringing a case of negligence on behalf of another person. That does not affect your PIP claims. If somebody's 99% at fault for an accident, they still get no fault benefits. 100% of no fault benefit, doc. Hopefully that answered. If anybody has any other questions, feel free to ask. But the takeaway for PIP, okay, not much is changing. The only thing that's changing is your ability to file a lawsuit against the insurance company. And you can still file a lawsuit, but you're only on, you can still file a lawsuit on new claims. Okay, new claims where the policy was purchased after March 24th. Okay, there's no attorney's fees, so you're going to have to give up a percentage of your benefits to get that money. Under the old claims, it's business as usual for me. My office has been filing 1,000 lawsuits a month since January 1st, way before all this stuff came up. This was like a Valentine's Day massacre. I was with my wife. We were in Vegas taking our first vacation of the year. So excited to go to Vegas for 3 days. And this is the news I come home to. I was like, oh, this is horrible. But it is what it is. We got to adapt, guys. And if you're able to adapt and overcome this, it's fine. You will be fine if you save your money, reduce your overhead a little bit, reduce your spending, and get new money from your old PIP suits. Okay. My office on average collects, and this is important because this is even on cases where 5 other lawyers went through the files. I collect on average $424 for cases. Each file you give me. So if you give me 10 files, that's on average $4,200. If you give me 100 files, on average $42,000, right? Think about it. Start collecting your PIP suit money now, because everybody, I'm telling you, my office has been off the hook receiving these PIP suits. We have 8 people meeting with people throughout the state of Florida. And they're like, Abe, I'm bringing in record numbers right now because of this law. People who used to say no, thanks, doc, you're welcome. People who've been saying, no, 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 I don't believe in PIP suits or whatever. Now all of a sudden they believe. Okay. And so, PIP suits are real. There's money there. Are you going to get dollar for dollar what you used to get? No, but you're still going to get something. And just as a final note, some people are saying, Abe, you're crazy, man. There's still attorney's fees. There's this thing called a proposal for settlement statute. And my friend, he kind of went to law school or knew somebody who went to law school, and they said that you can make money. I did that work. I did proposal for settlement cases on diminished value cases. You have to get a judgment. Getting a judgment means you go to a jury trial or you get a summary judgment hearing, which takes 2 to 3 years. And it's not as easy as it is right now. Right now, all I have to do is collect $1 for my doctor. I got to be the prevailing party. I got to get $1. Okay. Under the new law, let me rephrase. Under the proposal for settlement law, you have to make an offer to the insurance company. Okay. You have to wait 30 days. They could accept your offer. So you could say, hey, I offer X amount of dollars to settle my case. And, no, if you send me your PIP suits now, you do not have to pay. Well, I don't keep a percentage of anything. Right now, it's all the old law, and we would keep our attorney's fees, and you would get your full benefits. You don't owe us. There's no contingency where I keep a percentage. Somebody just asked me that. If you're the way I'm handling it is if it's under the old law, you get your full benefits, and I keep my attorney's fees separate. Under the new law, which there hasn't even been a car accident yet in the state of Florida, probably under the new law. But under the new law, I would call you and say, hey, doc, you're owed X amount of dollars. And we would work out literally a deal on that particular claim, because this law is so new. No lawyer has really said what they're going to charge for a lawsuit under the new law. But the demand letters, to send a demand letter under the new or old law, is still, you keep 100% of your benefits, guys. Okay. So just to go back to the proposal for settlement law, under the old law, I just got to collect $1 for you. And everybody says $1, but it's really a penny, to be honest with you. I just got to collect a penny or $1. Under the proposal for settlement statute, I would have to beat the offer that I initially made in writing. I would have to beat it by 25% in order to collect attorney's fees, and not just beat it, but I wouldn't have to settle it. I would have to get a judgment, which means the insurance companies are going to make me get a judgment on everything. Okay. And I've done that work on diminished value cases. Diminished value is when the value of your car is worth less money than it used to be because it was in an accident. I've done that work. It's not pretty. There's way more profitable things to be doing out there for a lawyer who can litigate, and proposal for settlements is not one of them. The proposal for settlement statute is designed to get cases settled, not to get attorney's fees, but to get cases settled. And if they don't settle and they go to trial or they go to a summary judgment and they get won and they beat the offer by 25%, then there's attorney's fees, the possibility for attorney's fees. But you got to have, and this is a funny chiropractic joke, you got to have everything aligned perfectly in order to get attorney's fees on those cases. And it's not going to happen. Somebody liked my joke. Thank you. I worked really hard on that. It was very impromptu. But does anybody else have any questions they want to ask before we end? If I think we covered everything. I sent you guys a couple of really good links. I would open them up in your phone. You could save them. The definite good ones are, one is to subscribe to my email list. One is to go to House Bill 837 on my site and see videos. You don't even have to read it. You can just watch videos. Oh, and I got one more. We are hosting Saturday, April 8th, next Saturday, 8 a.m. We're going to have a lecture for CEU credits, free CEU. You guys are welcome to come. You can go to one of these links that I sent you and find it on there. If not, figure out how to get a hold of me. But it's Saturday, April 8th, coming right up. Next Saturday morning, virtual. We're going to talk more in depth about this stuff as well. But if you guys want to do that, you're welcome to. And I want to say thank you very much to Rod at the FCPA. It was his birthday yesterday. It was his birthday. He turned 21. And for putting this together, he called me I think Thursday night last week, and was like, Abe, in the dead of the night, he's like, Abe, I need you to talk to everybody about this. We started talking about it, and then within 24 hours, we did, I think, almost 2 classes. Within 48 hours, we did 2 classes, and we're doing this one, and then we're doing 2 more on Monday. The ones on Monday are the same exact thing. Anya, Rod, do you guys have anything you want to add?